Yeah, I would say, looking at a chart of the topics that calls that Steph and I get, I think defects would be way up there. There's usually some kind of argument between buyer and seller over defects that are found in the inspection. And hope I can clear this up a little bit. It still doesn't take away the arguments. There are going to be sellers that say that's not a defect, and there are going to be buyers that say that is a defect, and I'm not going to buy the house unless that's fixed, and blah, blah, blah. And they even admit, WRA even admits that it's never going to be totally set in stone on how defects are determined. Even the definitions that we are going to go over are gray. And I think that's done intentionally so that a final determination of what a defect is in a particular transaction in a particular house is up to the lawyers or up to the courts. And so that's where Steph and I direct some of you when you're having these issues with a seller. It gets to a point where it's a legal argument, and that's when we have to take 3 steps backwards. So we're going to try and make it clear today what are defects and how they're defined and how you work with them in your transactions. So 2 years ago, June 1st, 2021, the Wisconsin passed a new statute that pulled the inspectors in to be a little more specific. Home inspectors had always been required to identify defects in their reports, but they didn't necessarily label them as defects, or they didn't have a summary page where they talked about what a defect was or found in the property that they were inspecting. So the new legislation that was passed on June 1st, 2021, now it says that they have to modify the definition of a defect. They label them as a defect in the report at the time of the inspection, and that's a very important phrase. They are labeled a defect by the inspector at that time of the inspection, and is not making any warranties as to the future condition of the property. That's where we get into a lot of dispute, especially things like roof, because a roof can be looking crappy and wrinkled and shingles curling and things like that, but no water is getting into the house. So the roof, even though it doesn't look good, is still doing its job. But the inspector is going to say, you know, probably has so many months or years life left in it and things like that, but they can't necessarily call it a defect because they're talking about the future condition of that roof. So Joan, at that time of the inspection, what the inspector sees as a defect defined by the inspector's definition.
Oh, I think Rob, yep, go ahead, Robin.
Yeah, I do. I mean, you know, Joan, I just went through that exact scenario, as you know, Steph. Mm-hmm. And you know, it killed the deal because there is nothing, the roof is not leaking, it's not at the end of its age, but the inspector, you know, unfortunately this ruling in June, so now what these inspectors are doing, even good inspectors, it's kind of like they're labeling anything that has a remote chance of being a defect. And it's very frustrating because they'll, like in that report, it said defect / repair. So he lumped it together so that a homeowner doesn't have a chance to even arbitrate. I mean, he can try, but because that inspector labeled it as such, and again, I had this roof exact scenario.
And-
Very
and-
frustrating, very
Right.
frustrating.
But it is written in the legislation is not making any warranties as to the future condition of the property. They can't project into the future that this will become a defect. And a roof supposedly is a defect when it's letting water in. But
And this-
again,
Yeah,
these are all interpretations at this point that are legal interpretations. And so sellers and buyers and listing agent and buyer's agent can hash this around with the inspector and with each other. But when it gets to that kind of interpretation, that's when the lawyers have to step in. And sometimes it becomes a lawsuit, and that's when the court steps in. So anyway, the new legislation has those things. They have to label them according to their definitions, inspectors' definitions, and they cannot make warranties into the future. Okay, next slide. So there are two definitions that we are working with here of a defect. One is in the offer to purchase, and it's also in the real estate condition report. And I'm going to point out the difference between this defect definition that we all have learned and used and been trained on, that's in the offer to purchase. It states a defect means a condition would have a significant adverse effect on the value of the property. Again, as I said in the last slide, these are written with a bit of a gray or around them. So there's some interpretation what significant adverse effect on the value of the property actually isn't how that's actually interpreted. B, that would significantly impair the health or safety of the future occupants of the property. So the future occupants either are the buyers that are writing the offer, have hired the inspector, and the inspector sees things that could a danger to them in their health, like leaking gas or the safety, electrical components of the property. Those are considered a defect if they are not repaired. And C, if not repaired, removed or replaced, and those words are very important, repaired, removed, or replaced, would significantly shorten or adversely affect the expected normal life of the premises. Now, that again is a very gray statement, but using those words, repaired, removed, or replaced, is an interpretation that you, the buyer's agent, and the buyer can put forth to the seller based on the inspector's report. And if the inspector has those defects listed in there, and it falls into this third portion of the definition, that if not repaired, removed, or replaced, would significantly shorten or adversely affect the expected normal life of the premises. So I know they're gray, I know they're vague, it is something that is open to interpretation, but as a real estate agent, especially a buyer's agent that is representing the buyer's concerns, you need to have these three sections of the definition of a defect memorized. You should be able to repeat these three conditions to your buyer, to the listing agent, and know them effectively. Again, when there's an interpretation confusion, then that goes to a lawyer's advice. But we have to use these sort of vague definitions to guide our clients, either the buyer or explain our client, the seller. Okay, now there's a different definition of a defect in the inspector's report. So because of this statute, 440, Wisconsin statute, they have the inspector's definition of a defect. Defect is a condition of any component of an improvement that a home inspector determines on the basis of a home inspector's judgment on the day of the inspection. And that's a critical phrase, on the day of the inspection. Something that the home inspector's judgment feels that A, would significantly impair the health or safety of occupants of a property, or that B, if not repaired, removed, or replaced, would significantly shorten or adversely affect the expected normal life of the component of the improvement. That's the home inspector's guide to how he defines a defect in his inspection report. What is the key word that is missing? We'll go back. What is the key word that's missing in the home inspector's definition that's not in the offer to purchase definition? There's one key word in there. Any of you pipe in and tell me what that word is missing? Okay, go to the next after. The key word is value. An inspector, home inspectors are not appraisers and cannot comment on the value of the property or its component. So in our offer to purchase definition, it talks about decreasing the value of a property based on whether it's a defect or not. But a home inspector can't comment on value. It is outside the scope of their license. They have not been trained with value. They don't know how to do comparable market analysis, all of that. And so they cannot use value or loss of value as a component to the definition of their defect. That's a key difference. And it's something that I don't think a lot of agents have been prepared to distinguish. So therefore, the two definitions cannot match. In addition, it is quite possible that while a home inspector does not label something a defect in the report, a buyer claims it is a defect as defined in the offer to purchase because the buyer claims the condition would have a significant adverse effect on the value of the property. This is key. The inspector didn't put the roof in as a defect because he didn't see that not repairing, replacing the value, or replacing the roof would affect the value of the property as it goes on. And that's where the offer to purchase definition of a defect is more inclusive because it talks about the loss of value in the property. And that can be the difference, Robin, where you were talking about in your situation. A buyer can add a defect that reflects the loss of value in his notice of defect, even if the inspector did not notice it, mention it as a defect. And it says this right in the WRA legal report that, again, this legislation is aimed to help reduce arguments between parties as to what is a defect, but it cannot eliminate all claims and challenges that could be made by a buyer and seller. So a buyer and the buyer's agent writing up the notice of defect take the defects that are listed on the back page of the home inspectors and they list those as defects that the inspector has found. But then there is a defect that has been mentioned, or there's a condition in the inspection that's been mentioned that the buyer's agent and the buyer determine if this is not repaired, replaced, or fixed, the value of the property would be affected. And so it says in this slide, they can add that as a defect to their notice of defects. So it is quite possible. So this is what it's saying. Can a buyer object to the items in the inspection report? yes, a buyer can object to those conditions that would have a significant adverse effect on the value of the property. Value being the key word. A home inspector cannot comment on the value of the property or its components. Because of this, there may be items in the home inspector's report that would affect the value of the property, but are not labeled defects by the inspector. This means that a buyer can object to the items that are defects, but not labeled as defects by the home inspector. So they've made that point a few times, but it is something that I think Steph and I puts us in a hard place when we're asked by an agent, you know, to sort of unravel these situations. But actually, it's the buyer does have the right to add these defects if it affects the value of the property. And when there's an argument, as they said, they're not going to get rid of all arguments over this. But when you get to interpretations, those become legal interpretations. And Steph and I really, our hands are tied to try to resolve this. And frankly, your hands are tied as a buyer's agent or as a listing agent to make those interpretations as well. Is this clear? Because I think this is the key thing that I wanted to try to get across today when we're talking about the definitions of a defect and where these definitions come from and why they're different in the inspector's report from the defects that are listed in the offer to purchase and also in the real estate condition report. Any questions?
Yeah, no questions. And Joan, thank you for, I mean, you're navigating through that. I guess, again, it just goes back to, you know, years ago, old school. If something was defective, it was, you know, the roof was leaking, you know, something else, where now, like you said, they've kind of created this gray area, which has, I don't know. I mean, I think in a court case, if something is not leaking, it's not, you know, replace fine or repair fine. But when someone is pushed, a seller is pushed to replace, when clearly it does not need it, that's an issue. And
right. And that interpretation is beyond our scope.
Right. Right. But it's just unfortunate because it's just very tricky. And how an inspector, you know, evaluates has a lot to do with what happens. Kind of like an appraiser. It can make or break a deal. Make or break.
When you talk about the way it used to be, there used to be a very renowned inspector that all agents feared because he was so judgmental and sort of ran his own business outside of the WRA. He was inspecting a property that I had. It was a big, old, beautiful house down the Lower East Side. You know, 3 floors, lots of charm, beautiful, but built probably in the early 1900s. And he's going through this. It took about 5 hours to have this inspected. And as he's going through, he's going, oh, he's talking to the buyer. Oh my gosh, how much did you pay for this? Oh, I can't believe you paid this much for this property. He was rating everything as, oh my God, this is going to fall apart by next month if you don't get out of here. Just those comments went on and on and on. And I kept trying to stop him, being the seller agent and being present at that inspection, because back then, my firm that I was belonging to at that time wanted all of us listing agents to go on all inspections. But anyway, this was a real trial. It went on forever. And we finally got back to the kitchen and he's still making derogatory comments. And he said, oh my God, what time is it? Oh, it's getting late. He said, I better call my wife and say I'm going to be late for dinner. And then he points to the phone that, of course, is hanging on the wall. And he says, do you think this phone works?
Wow.
And at that point, I wanted to strangle this guy.
Well, no kidding. That's awful.
Yeah. But that's why this legislation is a little bit better for us, because it does keep the inspectors to be uniform in how they respond and how they write their reports and what their part is. Robin, you're right. It's a lot like an appraiser. There's some good ones, there's some bad ones, but with this legislation, it tries to keep the definitions to be the same. The instructions for inspectors has to be the same, and hopefully get rid of inspectors like that old guy.
Because the hard part is, and you know, I've worked with many different inspectors, and there is, sorry, not to prolong this, but there is a difference when they have a report and they say, okay, now here are the things that I would label defects. Here are the things that should fall under repair. This particular report, there was no, there was no separation. He had defects / repair or whatever, all under the same thing. So it really was, I don't think that's right.
No, it doesn't sound like it was conforming to the legislation.
Right. So that was my hardship. Yeah.
Well, so for those of you who are have not yet gone through an inspection with a client, with the buyer client, it can be very confusing in this part of what do you do when defects are identified in an inspection report. Your buyer, your client has these choices, and I'm just going to go through them to make sure that they are delineated, especially for those of you who haven't been writing too many transactions so far. So number one, if the seller was not given the right to cure in the inspection contingency, the report comes back and the buyer can try to negotiate with the seller using amendments in the offer to purchase. But if no agreement can be made, the buyer can then send a notice of defects to the seller. That is an automatic termination of that offer, and the earnest money goes back to the buyer. That's why a lot of sellers don't like not having the right to cure. And in this competitive market, that's almost all we are seeing is giving the seller right to cure. But if the seller was given the right to cure in the inspection, the buyer can try to negotiate using amendments back and forth with the seller, back and forth. You know, I want this, and then the other party writes their amendment. No, you can't have this, but I want this, and it can go back and forth as much as you need to. But if no agreements are reached by negotiating, the buyer can then send the notice of defect to the seller. The seller can decide to cure the defects by sending a notice back to the buyer saying, I will cure. The transaction continues to closing with the seller curing the defects listed in a good and workmanlike way. That's what the offer says. I'll address that at the last slide. Or the seller can ignore the deadline to decide to cure, or send a notice that the seller will not cure, and then the transaction is terminated. So hopefully breaking these steps down on this buyer's choices helps you decide how you can lead your buyer into good decision. The parties, and I'm adding this highlighted thing because we're seeing more about this, say the notice of defect was sent, that normally triggers right to cure, and yay or nay. But say the buyer still wants the house, the seller still wants to sell, you can continue to negotiate after a notice of defect is sent by sending an amendment, and it has to include, number one, we remove the notice of defect dated such and such. So the amendment has to state that. And number two, then the amendment states the new ways to resolve this problem, whether it's a closing cost credit, reducing the purchase price, curing some things, but not all things. And both parties agree to that contract is put back together and goes to closing. So we're seeing more of that, but I've been getting calls from agents on how to do that. And it's basically you have writing in the amendment say the notice of defect has been withdrawn.
And this can be done after the contingency deadline?
Yes, yeah,
We don't have to extend it or move it. It's just, okay, we're renegotiating and that's fine.
exactly, exactly.
Okay.
Because it's out of the inspection contingency deadline when the notice of defect was sent. So that terminated the inspection contingency. But now we're into this sort of halo area of negotiating beyond that date.
I like to refer to it as like the election to cure period, and a new deadline is set with that 10-day, well, defaults to 10 days, but that 10-day period. So
Right. Yeah, it has, that's good, Steph. It has to be within that period of the 10
Okay.
days that the seller has the right to cure or not to cure.
That makes sense. So we're negotiating with the seller's right to cure portion now of this contingency.
Right,
Okay. So we do have a 10-day period for that usually.
right.
If that 10 days is up, then what?
Well, then the deal is either terminated because nobody has decided not to cure, or the seller has said they are going to cure and the deal goes to closing. The negotiating is done.
mhm.
If we,
So-
oh, sorry. Go ahead.
No,
Or you would extend, right, Joni and Steph?
You can
Just to
always
Add
extend
another, yeah.
10 days, that period
Okay.
that the seller has right to cure.
That was going to be my question. Thank you.
yeah, that was my question as well. If the seller does not have the right to cure, it's a
Not-
best practice to include an extension of that period in the amendment, correct?
Oh, no, if the seller does not have the cure, a notice of defect terminates it right then and there.
Correct, but if you
But if
want
the
to
seller-
submit an amendment to the offer,
Yeah,
then you can extend that inspection period to give you some room
yes,
for negotiation. Got
yes,
it.
yeah. You can always extend the inspection period.
Got
But
it.
once the notice of defect is sent, that inspection period is done. That
Mhm.
closes that. And it's either the deal is terminated because the seller doesn't have right to cure, or if the seller has right to cure, it goes into the next period, which is the 10 days of the seller deciding whether they're going to cure or not. So make sure that's all written out in the offer. It's all written out in the inspection contingency. So if your seller or your buyer are not quite clear, go over those lines in the inspection contingency, as it talks about what happens if seller has right to cure, what the different options are. It also talks out very clearly when the seller was not given the right to cure. That's when the hammer goes down, the deal is over.
Mhm.
Now, you probably could negotiate, but a notice of defects being sent at that point, but it usually is, that's usually decisive.
But I mean, if like this yellowed highlight said, even if they receive the notice, the amendment by removing the notice,
Mhm.
listing the new resolutions, you could add on an extension of the home of the, yeah,
The original inspection
Agency.
period.
Mhm.
right? I mean, as long as both parties agree to that,
Yes.
okay.
No, you can still negotiate when the seller does not have the right to cure also. But it
Right.
has to be done within that time frame or extend that time frame.
Or extend it, correct?
Would they sort of be overlapping though? Because if you extend the inspection contingency so that the buyer still has time
Well, then
to
you
deliver a notice and they're already delivered the notice, but then retracted the notice and then entered into the seller's right to cure period, would they then kind of be overlapping?
Well, we
If-
were talking about the situation when the seller does not have the right to cure.
Oh, sorry.
Then that has to be, that inspection contingency has to be extended first. And then
Okay.
they can continue to negotiate whether there's a notice of defect in effect or not. Well, when the seller does not have what seller does have the right to cure, then you have this second time period. And that's usually when new negotiations can be brought up. Remove the notice of defect. Let's get back to the table, talk about it, send amendments back and forth. And if there's still no amendments at that point, when the time is up, or even an extended period of when the time is up, that deal is either going to closing or dead.
Okay.
And the reason why as buyers, we want to rescind the notice of defects if further negotiations happen is because we want to eliminate the possibility of the seller still continuing to just determining to kill the deal, because they still technically could. So that's why you want to rescind the notice if
Okay.
there are negotiations afterward.
And you're never really, as a buyer's agent, you're never really sure whether that seller has another offer sitting there, a
Right.
secondary or another interested person. They don't have to tell you. They don't have to tell you they have an accepted secondary, or they don't have to tell you that they've got 3 more people that are waiting for this deal to fall apart. And so if you're not negotiating or not extending, you're actually getting ready to be on the chopping block.
Yeah, you're really
because
vulnerable.
the seller wants to get you out of there so he can go with somebody else. Okay, so I hope that's clear. It is something that you can always give us a call, but I wanted to throw in these important tips to remember regarding inspections, regarding dealing with defects. Number 1, and it's especially true for new licensees, we can't stress enough how important that inspection deadline is in your offer. And obviously following that right to cure inspection time too. But make sure that everybody in the parties know that inspection deadline and you all agree to it. The buyer, the seller, the listing agent, the buyer's agent all know that you have so many days left in that inspection period. You have to have enough time to go negotiate, to get estimates, and to do follow-up inspections. Sometimes buyers write a very short inspection time, like 7 days, because they want to appease the seller. But then things pop up and you want to get another inspector in there, and you might be having a, need to get estimates, and then you're at the mercy of the seller giving you more time. And maybe the seller doesn't want to give you more time. Number 2, insert the clause, and I didn't have it with me, but insert the clause in additional provisions in the offer. It's too late if you don't put it in the offer. But put it in the offer right up front that if the seller has right to cure, they are going to use licensed contractors. They're going to get lien waivers and invoices for the job. Otherwise, as I stated in an earlier slide, all the seller has to do if he's going to cure the defects is do it in a good and workmanlike manner. He can do it himself. So if you want to ensure that it's done by licensed contractors, lien waivers and invoices, you have to put that up front in your offer. In proposing negotiations in an amendment, and this is something I think a lot of newer agents don't realize. It's a practice that you develop over the years. Oh yeah, I should have done that. But I want to say it up front. If you're proposing amendments in negotiations in an amendment, add in there that if the seller agrees to these conditions, the inspection contingency is hereby waived. Because what happens, and I'll get a phone call, is they can agree to the negotiations, but everybody signs these negotiations are all agreed to. But guess what? There's still like 4 days left of this inspection contingency on the table. And things can pop up and they can get another opinion and things will happen. That agreed upon amendment is still in effect, but it doesn't mean that something else can't be added. Another amendment can't be added to it. Or even a notice of defect could be.
Yeah.
sent. So if you're looking for agreements, give them the proposed ideas, but then say, I'll remove the inspection contingency if you agree to this. Another important tip is in writing the notice of defect, and I'm just amazed. This has always been a stickler with me as a manager, but I'm amazed sometimes the way some agents, not at Keller Williams, and not at Coldwell Banker either, but some other agents, write their notice of defect. It really should say, stating up front, this is a notice of defect, and these are the following defects to which the buyer objects. So you're setting that introduction up, that what you're doing is just listing the defects. I've heard some agents say, well, I just went into the inspection report and copied and pasted the inspector's comments right there, so they know exactly what it is. And I'm saying you can't do that, because usually in the inspector's report, he's going to go into what he found, how he found it, what the problem is, and how it should be fixed. And none of those things belong in a notice of defect. The only thing that should be in a notice of defect is the name of the defect, the list of the defects that need to be cured. So how they're going to be cured, or why they need to be cured, or all of those things should not be in the notice of defect. Any questions about that?
Yeah, that's a big one. I was just talking about it in Accelerator the other day. Just, once you're past these attempts at negotiations and we're moving things to a notice of defects, the ability to dictate how things are done has gone away. So we just see that a lot, Joni and I, that people are trying to include how defects need to be repaired on the actual notice of defects itself, which is not the vehicle for that.
No.
Just reiterating.
If it went to court, if there was a lawsuit because of that between the buyer and the seller and it went to court, that notice of defect would be in the trash. The judge would say, no, that's not an effective, properly written notice of defect. So if the seller objects to any or all of the defects, so the seller goes, I don't believe that's a defect. That's not a defect. Blah, blah, blah. I refuse to accept that. I'm not going to cure it because it's not a defect. And I have this, contractor that told me that everything was just fine and there's no problem with it. So you're going to get into situations like that. And Steph and I hear about these situations a lot. If the seller is objecting to this notice of defects, saying they're not defects, that's when you have to call an attorney. Because Steph, nor I, nor you, nor the listing agent can resolve that. And they even say it. If you go into legal hot tips, all of that, they'll just say, please consult an attorney. Because it is now an illegal interpretation of what is a defect.
I think you covered up your microphone, Joni.
Oh, I did. Got it?
Got it.
I've been in many situations where they actually have gone to court, or they've gone to small claims court. It has been the result of a lawsuit, and that's when it's determined really what those defects are. So going back to the start of what I said today is know the definition of a defect, be able to recite them, be able to understand them, and appreciate the fact that the inspector's definition of a defect does not include anything about the value of the property. But the offer to purchase definition of a defect does. So the buyer can add defects that the inspector cannot if it talks about losing the value of the property. And that's hard because, as we all know, understanding value of a property is pretty much subjective.
Mhm. Tammy had a question in here. Could we address how to handle defects identified by appraisers for a loan when both parties agree to negotiate on those items?
Yeah, I read about that. And then there have been some problems with that, even that have gone to legal hot tips that I read about. That appraisers, even if it's not even an FHA or VA loan, that appraisers are getting in there and starting to make their own sightings of what they consider defects. They don't necessarily list them as defects, but they alert the lender to something that maybe the lender doesn't even want to know about or does not want to loan on, because it's a risk for the lender to loan on something that has this condition. So more appraisers are taking it upon themselves to, in a sense, warn the lender that, you know, this basement doesn't look very good, or this roof doesn't look very good. And there isn't really much we can do about it. It happens, as we all know, in an FHA or a VA loan. And in those situations, the seller basically has to repair those things prior to closing in order for the buyer to get their loan. So the inspection period may be totally done, over, satisfied, everybody's happy. But when the appraiser gets in there and he starts citing conditions that he think may jeopardize the lender from wanting to loan on this, it now becomes an issue of the financing contingency, the financing commitment contingency, and not anything about the inspection contingency. But
Is that legal?
Sure.
Is that legal, Joan? I mean, can appraisers do that?
They're doing it.
I know they are, but it's kind of like almost, okay, the inspector isn't supposed to speak of value. Well, because, and so it seems like it should go hand in hand. An appraiser is not an inspector. So
But they're
how is it?
they're commenting on value.
Yeah.
So
And they are ones that can talk about value where an inspector cannot.
Right. I
And
just,
so
no, okay.
that they're seeing, because of our competitive market, I can see where this has come from. They're seeing a lot of agents, or excuse me, a lot of buyers waiving inspection and not knowing about it. And now the lender is making a loan commitment on a property that maybe has a lot of risk to it because of the conditions. And so the appraisers are taking it upon themselves that this is lowering the value of the property. This condition is lowering the value of the property. The appraiser feels that it is their responsibility to let the underwriter know this. And so yes, it's legal. It's come about because the lenders are getting burned by loaning to some properties that probably shouldn't deserve a loan. And because of that, the appraisers are taking it upon themselves, or maybe they're being directed by the underwriters, I'm not sure. But they have to be more like an FHA appraiser. I've had this happen to me. I've had this happen to many agents that I've been helping. I had a duplex in Shorewood. They were two sister duplexes. They were beautiful. And it wasn't an FHA loan, but they didn't have, there was some weakness in the foundation on the adjoining wall in the basement. And out of the blue, inspectors never saw it, never mentioned it, everything was fine. And the appraiser came in and flagged it. And my seller had to get that repaired, and that was very expensive. These were large twin duplexes. But as Steph said, this is about value. It's not about condition.
I think that a good comment to make is that, or just a comment I want to make, I should say, like, we want these things to be black and white so desperately, and they're just not. And it's really frustrating. But just like, there's just sometimes there's no rhyme or reason. I just was thinking of an example of a listing that I had where there were two buyers. The first buyer fell apart. It got far enough along that there was an appraisal. The appraiser made requirements that needed to of the home that needed to be done in order for it to close. It ended up falling apart, I think, on just the original inspection report. But then second buyer comes in and the appraiser didn't flag a thing, you know? So it's just like, you just don't know who you're gonna get. You don't know what mood the appraiser is in that day, you know? It's just like so many things like that that can just like affect how a transaction goes. And it's just, we want it to be black and white, and it's not. I don't know if that is a helpful thing to say at all. It's just reality. I don't know.
Can I ask a question about negotiating when both parties are agreeing to discuss anything that comes up on appraisal that needs to be mitigated prior to funding the loan? I do have that going on right now, and appraisal's ordered for Tuesday. So when it comes back, I'm kind of wondering, we're saying that with the seller that, yeah, we'll negotiate on anything that's over $500. We're expecting everything to be small, but if they find something that isn't, I'm just kind of wondering how do I protect my buyer? How do I,
This
what-
is not an FHA loan?
this is FHA.
Okay. Well,
So I just want to kind of touch on it a little bit, just to see if there's places and areas I should be aware of where I need to be mindful and careful for my buyers moving forward with that type of agreement with the seller.
you can get a list. I'm not sure where to get it at this point. But there is a list, you can get it from a lender. You can get a list on what an FHA appraiser looks for.
Okay.
And if you are the listing agent, that's something you can show your seller from the very beginning. Okay, we've got this really good offer, but it's an FHA. So we're going to have an FHA appraiser come in. And these are things that the FHA appraiser looks for. They have a very enclosed list. It's not, anything that they see. There are definite signature items that an FHA appraiser will look for. And you can get a list of what those appraiser items are from a lender and help prepare your seller. So it may be some things that the seller can fix even before they put it on the market. Usually a lot of those things are not large, but they are, as I said, on a list that a FHA appraiser will for and will
Okay.
sure that it's done.
I'm on
So-
the buy side of the transaction.
Okay.
So we're talking with the seller saying when we entered into the contract that we would negotiate on anything over $500 that the FHA
That's right.
appraiser finds. So on my buy side, I'm looking at what types of things should I be aware of if we have to enter into any of those negotiations?
You had that in the appraisal or in the appraisal part or in the inspection part?
This was for the appraisal. Yep.
Are you trying to communicate to the seller that the buyer would take on repairs over 500, or
No.
what's?
We would, when we got our offer accepted, we agreed. So I got a counter. And the seller countered saying that anything, because they see it's an FHA loan, the seller asks the buyer to take care of any items that are under $500 that come up on the FHA or come up on appraisal for the FHA loan to fund. Anything over $500, we would agree to negotiate with the seller.
Well, it's difficult because there's not much negotiations you can do. Like either they have to be done no matter what. So what you're going to be negotiating on is who's going to take care of it. So,
Right.
and take care of it before closing.
Right.
So there's a lot of risk for a buyer to take care of these items when they don't even own the house.
Right. So they took on the risk of anything under $500 and said that's fine.
Right.
And if we enter into anything that's over that amount, we would have a discussion and negotiate with the seller.
Okay. But you really have to negotiate with the lender because
Yes.
it now becomes a financing ability instead of between buyer and seller, it's between buyer and lender, buyer and underwriter. And if it's an FHA thing, you know, they're not gonna take things off the list, or they're not going to take reduce the purchase price, or they're not going to get a closing cost credit to conform it. It's the lender saying these have to be done prior to closing, period, or you're not getting a loan.
Gotcha. Yeah, there's that part of it. And then
Mhm.
we're working with the seller to say, hey, these are the items that we need to have fixed prior to the loan to fund. How
Mhm.
are you going to work with us on that? Are you going to fix these items and help us get to closing?
Well,
Right.
that's where it's just gonna have to be a seller's prerogative at that point. I guess there's nothing that you can get ahead of at this point to protect the buyer. It's just gonna be a
See what
determination.
happens.
Yeah, we're just gonna have to see how the seller responds. If the
Yeah, and
seller,
as I said incorrectly before, I thought you were representing the seller. You can prepare the seller for those things if they're looking at an FHA
Yeah.
loan.
Right. And I've done
Negotiate,
that on the sell side, sure.
buyer and seller really can't negotiate that much because those things have to be done or there's no loan.
Right. And I understand that. I'm trying to look out for my buyer. I don't want them to end up, doing all kinds of stuff and somehow the loan doesn't fund and then they're out all this money because they made repairs on this
yeah,
seller's home.
I suppose in the amendment, you could say if for whatever reason and closing doesn't happen, then buyer to be reimbursed by the seller, but that, I mean, it'd be very challenging to enforce that probably. I don't know. It's,
Yeah, it's always risky for a buyer to do anything in a property when they don't own it.
Yeah. And in this market, they're doing it because they want it. They want a
Right.
house.
You're right. You're
I
right.
mean, that's like reality is that's how they can get these loans with FHA, excuse me, how they can get their offers accepted with FHA loans.
Right. Yeah.
Why don't we talk about this when
Okay. Yeah.
it comes? Yeah, but I'll
Now,
be,
remember, we have Blake Early coming next Monday.
Oh, yeah.
And he's going to talk about financing issues. So maybe this is a good discussion to bring up with Blake.
Yeah.
So tune in next Monday, 12 to 1 in contract training, and we'll talk about financing problems.
Yeah. And I'll hit up Steph this week because appraisal for us is on Tuesday,
Okay.
tomorrow. So thank you.
All right. Well, thank you all. I hope we answered some of your questions and prepared you.